Welcome. Thank you so much for joining us today. This is our webinar series for life sciences, and we're looking today at partnering, licensing and research collaboration transactions. We'll have a discussion between us, and I'm really delighted to have with me James Fry, who is the head of our life sciences practice. James, as you'll no doubt be aware, works with large and small life sciences organizations and is busy across a range of different kinds of commercial relationships, working with them on gaining their strategic objectives. We also have Rebecca Oster. Rebecca is in our dispute resolution team. She's a specialist in disputes and managing them and helping to resolve them with the minimum of fuss. So these colleagues will be able to contribute on our discussion of partnering, licensing and research collaboration transactions. So to begin with then, with this opening slide, we have what we feel are the sort of issues that we'd like to talk through during the course of the session today. So perhaps I could start by asking James to have a look at the overview of the kinds of transactions that we are seeing at the moment.
Thank you, Isabel, and yeah, good morning to everyone. As Isabel mentioned, my key focus is in relation to licensing and partnering transactions, either acting for the rights owner or the licensee. 2023 was reasonably busy for us within the licensing and partnering space in particular, particularly between biotechs and pharma businesses. I think we generally feel that 2024 will probably remain busy on the licensing and partnering front, and I think the industry generally has probably got a bit more optimism. So probably that there will be a focus on these sorts of transactions going forward. M&A is coming back. I mean, I think probably we saw last year that licensing partnering deals were being executed really as an alternative to investment to M&A. You may look at some of the sort of drivers for that. Maybe going forward, more of the focus is actually going to be on deciding whether out licensing in particular, say for a biotech or medtech company, is going to be the right option over M&A or joint venturing. So what are the drivers in relation to that? Pharma, big corporates, they need to partner to build their pipelines of products. Biotech or medtech company at an early stage, licensing deal bring in non-dilutive cash for further investment into other programs, technology development, etc. For global pharma and other corporates, many of whom are pretty cash rich and have been, it presents a route to building that pipeline. And as many of us know, most new therapies have come from small and earlier stage biotechs originally, but these sorts of deals provide the licensee with access to new technology areas, such as in relation to cell and gene, AI. For pharma in particular, they can also hedge some of the revenue risks around changes to US pharma pricing regulation, particularly around the Inflation Reduction Act, which I'm sure we'll come to and talk about. In terms of the sorts of deals we are seeing are some of those transactional trends, particularly in the context of licensing and partnering transactions. There's a number of themes we're seeing in terms of the nature of those transactions. So number one, sort of focus on some of those hotter areas, such as cell and gene, such as AI, where bigger corporate may not actually have that capability. These sorts of deals also are slightly different because quite often they're a collaboration between a tech provider and a more traditional life sciences businesses with very sort of different styles of development, much sort of more fluid development in, for example, sort of the AI or digitation space. And again, we'll probably come back to that as a theme. And the second thing we've seen a lot of innovation in the supply chain. So between CDMOs or between a CDMO and drug sponsors, maybe around sort of drug delivery type mechanisms. Again, quite a focus on AI and other advanced technologies. Yes, we've seen more. We have over the last year seen more focus on later stage asset deals, although encouragingly, we're also seeing a lot of early stage deals too. I think we would sort of generally take the view that many deals now will have a collaboration co-development phase. It obviously sort of leads to more complex IP treatments. Again, we'll come back to that. More framework type deals. So deals between, for example, a biotech and pharma company across multiple assets, across multiple development programs. And I suppose finally, we've sort of seen the hybrid models, quite a bit of joint venturing where there may be asset purchases, and aside from that, sort of in licensing, out licenses of IP. So sort of a myriad of different themes we're seeing, which I think we'll see sort of taken into this year.
And on the financial side, I think we're seeing more variety, are we not, in relation to the structuring of how those payment structures are being put together upfront versus contingents and so on.
We'll see the full myriad, Isabel. I think it's true to say we're probably seeing a huge variety of different financial models, particularly in the context of licensing transactions. Probably come back to that later on in terms of concepts around sort of royalty reductions. But yes, in terms of that dynamic between your upfronts and your contingent milestone payments, I suppose a layering around milestones. You may have those tranched across sort of tech development, sales, against royalties. So sort of a full myriad of different issues. Yeah.
So those old themes of pharmaceutical companies needing that innovative new technology to be able to move their pipelines forward, alongside the smaller research entities or startup companies needing the injection of cash in order to move forwards. Those old themes, but in a greater degree of complexity, the way you're describing it.
Very much so. Absolutely. Most of these deals sort of focused on the specifics of the deal, but I suppose what we are seeing, and maybe because of the international elements, some uncertainty in terms of different regulatory regimes, particularly in terms of product, is sort of driving a huge variety of different models. And I suppose one of the trick for the sort of in-house officer, in-house lawyer, contract officer is actually sort of trying to construct a model that is going to fit for that deal.
So Rebecca, perhaps you could talk about some of the themes that you're seeing at the moment in litigation, in technology and life sciences fields.
Yeah, thank you, Isabel. Yeah, I think James has kind of flagged, I mean, litigation is obviously going to follow somewhat the trends that are going on in the industry. There's been an uptake in kind of claims and cases against these new AI and tech companies. So that's something we'll see with disputes in the industry, particularly in collaboration and licensing agreement. We see a lot around sort of commercially reasonable efforts clauses and the obligations that fall within those. James just mentioned the different financial modelling, and actually that's a kind of rife area for disputes in terms of royalties, milestone payments, disputes about upfront fees and how those financial models work. So I think as these kind of technologies and stuff develop, we're seeing more and more of that. And it's just important to try and get ahead and in that kind of initial negotiation phase, think about what might help prevent a dispute later down the line.
So looking forward whilst you're doing that drafting in order to try and see what might come and trip you up at a later stage and cut it off.
Exactly, yeah.
That's great. So we will now turn to some of these themes in slightly more depth, and we've got 4 areas broadly that we'd like to cover. And to begin with, it'd be good to focus on some of the trends around intellectual property. And I mean, obviously, the licensing of intellectual property is at the heart of this kind of transaction. But we're seeing some new themes and trends, and it'd be good to dig a little more into what those look like. James, could you comment on what you're seeing there?
Talk through this in terms of some of the, so these are sort of some of those sort of contracting trends we are seeing in sort of negotiations around these kinds of deals. I mean, whether it's AI or it's some other sort of new advanced technologies, you're seeing a very different sort of IP mix. So you're seeing a lot more in the context of sort of software IP around sort of rights in data, software copyright, database rights as well. Often with these.
That's a big change, isn't it? Because in life sciences, it's historically very much been around patent protection and the licensing of patent portfolios. So this is a new challenge, really, isn't it?
It is a new challenge, and really it's making sure that almost if you're using those sort of more traditional models, that they're gonna fit with that IP mix. I suppose one of the issues around AI technologies in this space is you're probably less able to almost crystal gaze in terms of what the likely outputs are going to be if you've got a sort of a collaboration or sort of co-development phase, and less able to almost sort of distinguish the respective contributions of the parties to the new arising IP, which I think means that you've probably got sort of more complex IP constructs around ownership, cross licensing. I'll come back to some other issues that are sort of driven by AI in particular. But I suppose what you are doing is sort of thinking through the different types of IP constructs. So do you seek to define IP by reference to if it's around you are the licensee, the development of your own product, are you able to sort of distinguish between rights attaching to the product versus sort of the platform and the base tech that the licensor is applying to the collaboration? But also you're thinking around improvements. Improvements are going to develop over time. Are they going to be more iterative, or are they going to be more fundamental, and really coming up with an IP construct that if you're the licensee, you've clearly got control of what you need to be able to sort of develop and commercialize the product. But if you're the licensor, you're also sort of maintaining some control over the technology that is being applied to the collaboration. You've got control over those iterative improvements that are made as part of the collaboration. So inevitably there's going to be a balance in relation to that. I mentioned these sort of framework type deals where effectively you've got deals across multiple assets, multiple programs and technologies, which obviously presents sort of greater complexity around IP treatment, because you may have different work packages with one party contributing more on others. So you may actually, almost on a piecemeal basis, being sort of formulating an IP construct that crosses the divide between each of those different areas. I actually did a deal recently whereby we had that co-development phase up from ahead of the commercialization license. The patents that were likely to be filed would cross each of the different areas, and so we were coming up with a patent strategy as part of the IP license that was more umbrella. So one party was applying more for umbrella type patent applications that then within the context of the IP agreement, we needed to almost break apart at a later date to reflect each party's sort of IP ownership. So some of these are quite complex arrangements. I suppose in terms of AI, you've also got issues.
Jump in there because as Becca was saying a moment ago, if you're working on this kind of umbrella arrangement, there's quite potential there for the parties to fall out in future and potential for points of dispute. So I guess getting that drafting really hammered out early would, so important, isn't it?
I think that's right, Isabel. And I mean, you probably hear it quite a lot in the next 45 minutes or so, but there is going to be a real focus on sort of negotiations and that making sure you bottom out those upfront arrangements, so it really works for what you're trying to do. And I think with the development of these technologies and AI and personalized medicine, data rights, all of that stuff is just going to combine, but it's really important and actually often easier to sort of bottom out some of those issues at the beginning of the arrangement rather than later down the line when a dispute arises. I think at that point, parties are wanting to work together and be collaborative, and that's the time where actually, although it may be a little bit time intensive to bottom out some of those issues, it'll be sort of beneficial in the long run.
Yeah, James, so you were talking about putting those complex collaborative arrangements in place with, ownership of the patents across the different types of technology. I mean, do you find it a difficult matter to try and hammer all that out in advance, or is it just a matter of putting the work in?
There's a lot of, it's about clarity. I mean, if you think about sort of these kinds of deals, you know that a major focus of the negotiation is going to be around IP ownership and cross licensing of rights, and then effectively how that sort of moves through the collaboration. So in the event of a termination, how do the rights pass back to the individual parties? A lot of this you can deal with upfront through things like term sheets. I mean, the term sheet will set out the key principles for ownership. It won't include all of the necessary provisions that you need, but you can seek to agree and get clarity around some of these key issues up front. Certainly in terms of getting that sort of umbrella model battened down in terms of ownership, some of the key rights that may arise.
I think there's also no harm in sort of making sure that periodically or whenever it might be that there's a milestone, revisiting the terms of the arrangement, and that can sometimes just help sort of nip any potential disputes in the bud at an earlier stage.
I mean, the other thing to be thinking about, which I think gives you, I mean, where you come back to this in the context of sort of mitigating issues around potential disputes, is getting the governance structure right within the agreement as well. And so using those common constructs of having sort of for these bigger ticket deals, joint steering committees, joint development committees that will allow the parties to engage in a collaborative way to make decisions around IP. Because Becca's absolutely right. It's not just the upfront agreement, it's how that dynamically progresses through the collaboration. And obviously a lot of these deals are very, very long term. So having the right governance structure will allow, almost foster that collaboration between the parties, so that you're dealing with issues or conflicts as you go within that sort of within the environment of those that kind of governance structure, and almost prevents those deadlock issues
Yeah,
potentially
I mean,
potentially happening.
one of those is the unitary patent, isn't it? The new EU cross EU patent, and you have to make decisions at key points, don't you, as to how you're going to, whether you're going to opt out or what approach you're going to take, and that's something that requires timely cooperation between the collaborators in order to get it right.
It does. It's those sorts of decisions, Isabel. Absolutely. It's around your patenting strategy because you're going to be filing patents if you've got a code, or you're probably going to be filing patents. You have a co-development phase, and then it's dealing with those sort of those regional patenting issues, such as unitary patent, such as potential sort of US patent issues
And
as well.
the parties might not be happy with might not want exactly the same approach, but addressing that in a constructive manner as it happens is got to be the best way forward.
Yeah, absolutely.
That's great, thank you. So now looking at our second box here on the slide, we're now going to have a home in a bit on the financial structure of deals and what kind of trends we're seeing in the models that are being used in this kind of transaction. As I understand it, James, you're seeing a lot of variety and complexity and different structures there. So perhaps you could dig into that a little bit.
Yeah, no, absolutely. I think as I already mentioned, you're just seeing much more variety in terms of actually financial modelling. I mean, we're even seeing deals whereby the biotech will out license. They may be more of a platform provider, but they may be waiving royalties further down the line in return for sort of more larger upfront. So we are seeing really massive differences across different deals. I mentioned sort of the multi-layered nature of milestones now, and really looking to apply those milestones through the development pathway. So maybe looking at technical milestones around the co-development phase, separate development milestones as the product sort of proceeds through the clinical development pathway, and then sales milestones as well. So that multi-layered approach, I think, is key. I think there are two risk areas around all of this. The first is actually sort of hitting the milestones and sort of being clear that a milestone has been hit and triggers a payment. Obviously, this is more of an issue for the licensor or the rights owner. I suppose the difficulty at the moment is that some of the regulatory regimes, regulatory frameworks are in some kind of flux, and things change. And so the key thing I think about defining some of these milestones is to building that flexibility. I mean, quite often what we're saying is actually we've got a broad statement, and then we're saying, and this may be X, Y, and Z. And so providing real clarity for the rights owner in terms of that milestone is hit, it triggers the milestone payment.
The way you characterize the milestone is also going to vary from one country to another, isn't it? And the way you describe it is not going to be exactly the same.
And across different products as well, Isabel, and we may talk about sort of regulatory pathway and impact within the licensing agreement, the partner agreement a bit later on. I think the other big area is reach through. Because these new types of tech, whether we're talking about AI, whether we're talking about cell and gene, for example, there may be a real risk for the rights owner that the developed product does not trigger the milestone payment, the royalties. It's something different from what was envisaged. And so this whole issue of reach through, I think, is a risk for the rights owner. So I think it's really giving a lot of thought to how the licensed tech will potentially integrate with the partner's IP, the partner's platform, linking payments, not just what is licensed, but what is developed as part of any collaboration phase, any co-development phase as well. But I think it's giving some real thought to making sure that effectively, because you're combining IP, you may be creating something different that is then developed. Does that then trigger the milestone? Sorry, Isabel.
So we were talking earlier about the need for precision and pinning things down in the drafting, but what you're describing now may require a little bit more flexibility to be open to the different kinds of results that could come in down the line, and allowing for those to trigger potentially a milestone payment or royalty.
Absolutely. It's really thinking through the potential integration and interaction between the different technologies at play, such that you're able to give some sort of sense in terms of what may result, and then you can construct your milestones, your financial modeling from that. But I think given the nature of some of these technologies, it requires probably a lot more thought in terms of just making sure that the wording is right and does what is intended to do.
Mm.
I think that's right. And I think there is that balance to get between building in that flexibility while still having that it's not kind of mutually exclusive in terms of having care over the clarity and the kind of language and wording used in those definitions and other elements of the kind of royalty structure that you can define. And I think in from a litigation perspective, there has been again an increase in cases that we've seen coming through the English courts in particular. Last year there were 3, at least I know of, relating to royalty payments. And an interesting one, Isabel, you mentioned it earlier, is this kind of interplay between how different jurisdictions and internationally may interpret the royalty clauses. And I think one of the High Court cases last year was looking at that question. It was English law and jurisdiction that applied, but actually the English court looked at the misuse of patents, US provisions, and sort of, although it didn't apply it, but when looking at whether the royalty included total sales or just sales which may have infringed the patent but for the license, they did look at how different jurisdictions interpret those provisions. So it's having a mindfulness of kind of the language you're using and defining those terms sufficiently enough while still building in those flexibilities.
It's a real balancing act, absolutely.
Yes. So we've got the standard approaches to payment structures, which are, the royalty and the milestone. But I think you're seeing, James, are you a number of different kinds of permutations of those as we go through the current moment?
Absolutely. I mean, we're regularly advising licensees, so we're sort of pulling together clauses which would seek to deduct from royalties from milestone payments, but also on the other side acting for the rights owners. And I suppose what you're seeing is actually more categories of scenario where that would be deduction. And what they do, I mean, most people on the call will know, but if one of these scenarios applies, so for example, it's launch of a generic drug, for example, and the license deal relates to the originator therapeutic, then there is downward pressure on the royalty and milestone payments, really on the basis that the licensee is not going to be able to exercise the same degree of commercial exploitation with the generic competitor. So we're seeing all the standard ones, which most people will know. So no patent rights, generic entry, royalty stack, which is effectively that there's an infringement risk and the licensee needs to go out and seek a third-party license and is able to deduct, for example, a proportion of the payments against the royalties. But we're also seeing more royalty reductions, which I think is driven by regulatory changes, and particularly regulatory changes in the US. So an example there is in terms of the Inflation Reduction Act. So if the drug that is coming out of the collaboration falls subject to that regime, and that regime will limit the price of the drug can be sold within the US, then again that should have downward pressure on the royalty. So we're seeing sort of a greater plethora of these kinds of reductions. I think commercially it's thinking through, yes, it's standard for those to apply to the royalty, not necessarily standard for them to apply to the milestone payments. But then if you're if you're the rights owner, thinking about royalty floors. So we quite often would say we're acting for the licensor. Well, you've got all these reductions that can apply, but our royalty cannot reduce by more than 50%, for example. So it's thinking around those kinds of protective measures, because quite often it's quite difficult to almost piece together what the potential impact may be further down the line.
Got a couple of questions just popped up. One is around reach through, and if you could explain a little bit more about what that term can encompass. What does it cover?
Yeah, so reach through we mean here by ensuring that what comes out of the collaboration actually falls subject to an achieved milestone, such that the rights owner gets the milestone or gets the royalty payment. And I think the point that we were making there is actually, given these new technologies, it may not necessarily be clear what may be created, and it'll be what is developed that will trigger the milestone. So that's really what we mean by reach through. It's a risk for the rights owner.
Thank you. And then another question around minimum guaranteed royalties and what we're seeing in that area.
Yes, I think it depends on the type of deal. I mean, you may not see those in the context of drug deals. I mean, you may see them in the context of other kinds of technology deals. And so, yes, there may be a minimum royalty that has to be met, failing which the licensee may have the right to top up. And if it doesn't, then either the agreement is terminable in whole or in part, or the exclusivity will be taken away. So yes, you will see those kinds of provisions.
And a question around the Inflation Reduction Act. The questioner asks whether that would primarily impact milestones rather than royalties. As royalties are percentage, you can still claim the same proportion of the pie, just the pie will be smaller, whereas the milestone amount may be disproportionately high if the sales income is lower. I suppose that's right, isn't it? But
it is. There are different issues as to whether the reduction would apply to both royalties and milestones. I mean, the argument that's been run that we've seen a lot is the licensee saying, well, actually, it will impact our profit, our cost efficiencies, etc., which means there needs to be a reduction in the royalty. I mean, it's a relatively new provision that we're seeing, and we did see it in a number of being requested in a number of deals last year.
So how that will play out is still a matter for uncertainty.
Yeah, these are always negotiable. They're always negotiable, and I think when we get some sense within the US as to what kinds of drugs would be subject to the regime, then again, parties executing this kind of transaction may be able to get comfortable that there may not be the impact. I mean, many people will be aware that there are exemptions to the IRA, such as, for example, orphan drugs, which are treating only one condition. So you may be able to get comfortable in terms of what is being developed.
And is there at the moment a trend towards extending royalty term beyond the term of the license, even so the payments last longer than the actual license of intellectual property?
We are seeing this asked for. Absolutely, and the argument goes, well, the licensee will often have a right to terminate for convenience, and so it could almost sort of game the position, terminate. And so the provisions will tend to say, well, actually, if products are being developed using the technology that are then sold afterwards, then a royalty should apply. So yes, we are seeing provision, discussions, negotiations around post-termination royalty obligations, and also an extension of the normal sort of, quite often in the drug space, it tends to be sort of, you'd have it for 10 years, for example, after commercial launch, that people are asking for longer periods. I often do if I'm the rights owner as well. So
very much
again,
depend on the details of the transaction, I guess, won't it? Whether
Absolutely,
that's a
absolutely.
flyer or not.
Yeah.
I think that's right. And again, it just comes back to sort of we're moving away and shifting away from being able to pull out sort of precedent contracts and actually looking at the terms for each agreement and making sure they fit. And where you've got those kind of extension of royalty payments, making sure that the termination rights and when termination rights and the sort of follow-on obligations arise match up, because you might not feel obliged to sort of carry on payments if it's been terminated for convenience or whatever it might be. So just making sure that the kind of wider issues are addressed at the same time as those extensions.
Yeah, tying those two areas together. Yeah. Okay. The next area we're going to look at is some of those non-financial obligations that are shaping the deals we're seeing. Perhaps we could talk a bit about the commercially reasonable endeavours type obligations we're currently seeing being asked for.
I suppose that often they are defined. Sometimes I've seen over a page or two in terms of what you mean by commercially reasonable efforts, and usually this is directed around the development of the product by the licensee and then the commercialization. I think it's always about making sure that it fits with the deal in hand. You'll tend to find out sort of these fairly standard definitions are applied, and it's a case of really sense checking it to what is the nature of this specific collaboration. I mean, what we tend to do as well is if we know that the licensee should be doing X, Y, and Z, then we build that into the wording and say, actually, in order to meet the CRE obligation, the diligence obligation, the licensee must be doing X, Y, and Z. It's an area for dispute. And I think, Becca, you did mention that, yeah, you often see, and I know I've been involved with you in terms of issues around CRE, particularly if we're alleging breach of CRE.
Is it
Yeah,
right,
and I think
Becca, that it doesn't have a standard meaning if a court's presented with those kind of words?
kind of so in sort of English courts, they have got a common law interpretation of what might be meant by sort of reasonable endeavours, all reasonable endeavours and best efforts. What we find, especially in life sciences and tech, is that those definitions don't always fit. And that's where, as James said earlier, a lot of parties are kind of coming to their own definitions. And I think that probably is the right approach, but there is the risk of leading to more uncertainty. And sort of if you've got 9 out of 10 obligations defined to that extent, and then the one that isn't defined very well falls onto a common law interpretation, it creates that uncertainty as to, well, what does it mean? Is it going to be applied with a kind of subjective test or an objective test? Are the kind of smaller companies going to be held to a higher standard, such as like a big pharma, and kind of what they would have done in the circumstances and what those effort obligations are? So it is a very heavily litigated area, particularly in life sciences. There are different things to do to mitigate the risks, and I think again looking at sort of how you define it, and it doesn't necessarily have to be a kind of really lengthy definition, but looking at what is appropriate for the two parties involved in the particular agreement. I think thinking about different options of sort of audit trails and monitoring and going back to that governance piece, and I think that ties into the milestone payments as well, is what progress reporting is there going to be? What happens if a party isn't meeting those kind of reasonable efforts? Does it mean it's material breach and there's a right to terminate, or does it mean there's just an infringement of the license? And sort of going into that level of detail, and again doing it up front rather than once a dispute's already kicked off, because at that point it can become quite difficult. It can have an impact on sort of future relationship and delay of product and that kind of thing.
Yeah, once one side has started to feel that the other side isn't really measuring up, then it becomes much more difficult then, doesn't it, to
Yeah, that's right.
keep that collaborative process going. So in terms of regulatory compliance, James, you mentioned earlier how there's so much change in this area and around different parts of the world. So there's a greater focus, I think, on this area in transactions. Is that right?
Yeah, but I think there's also the need to sort of step back and think through the different regulatory regimes that will apply to what is being developed, particularly if there's going to be co-development as well as then clinical development and commercialization to get the product to market. So, for example, as many people were aware, the National Security Investment regime may well apply to an exclusive license. So there's some sort of sense in terms of understanding whether it does apply and whether a notification needs to be made. There's focusing on sort of antitrust compliance, making sure that there's not really any issues from an antitrust perspective, and bearing in mind also that the regime there, particularly around technology transfer, is due to change. But I think in terms of the impact on the agreement, it's thinking around some of those issues we've already talked about, particularly around describing and defining the milestones. There is going to be an issue in terms of thinking about who meets the cost of change, given that a lot of these things may change in the future, and these are international global
the
deals.
life of the deal as well.
Yeah,
so
and they're
got
absolutely,
a long
they're international. They are, and they go on for a long time. It's also thinking around some of the new technologies that are being used. So if AI is being used, then almost in terms of thinking about what is being developed and then getting that through the regulatory pathway and out the other side, there's probably a need to have more input, more assistance from the tech provider. So you're probably thinking about those technical assistance obligations. So if a regulator asks, how does the technology work? Hopefully you got that information, but you may need to fall back to the tech provider to also assist you if you're the licensee. So I think it's thinking through, almost stepping back and thinking through what parts are going to apply here, and then looking to work through how that is dealt with in the context of the agreement.
And again, I think that just building in, sorry, Isabel, just building in, having stepped back, building into the contract or agreements or kind of relationships, the information sharing of, how does that product work, and getting that expert input and making sure there is protection. I think we've had one recently where there was a bit of a conflict of there wasn't the information sharing from over here, so it created a bit of a blocker. So it's just having that kind of protection built in terms of that information sharing.
Yeah, and one area where this might really come into focus is with the AI-related legislation. For example, the EU's AI Act that's just passed, and there's going to be a need to understand how the AI technology has been operating, and you're going to need to reach back to the AI provider in order to be able to meet those obligations potentially. So remaining in contact and close collaboration is really valuable there. Another area here, I think, is around termination rights and the consequences of termination. James, is that something that you could comment on?
We always need to plan for if things do go wrong, and a party needs to exit from the arrangements. I think drug discovery in particular is always uncertain, isn't it? So there may be a need for either the rights owner or the licensee to exit. I think one of the risk areas is because you will have standard termination rights around material breach, and that can probably come in on this in terms of almost thinking through, actually, are we in a breach scenario, or is it no fault? I mean, what we're tending to find, because there may be a whole plethora of different scenarios where a party needs to exit, you're then thinking through almost the termination consequences that should flow from each of those termination rights, and they will be different if a party is at fault compared to where a party, for example, terminates for convenience. If you've got a scenario whereby the licensee is terminating for convenience, then what rights does the rights owner have to whatever's been created? Thinking around almost the portability of the rights package thinking around that, such that the licensor is potentially able to do other deals in the future. So thinking about access to that developed IP.
Yeah, and I think again, termination, not just in life sciences, but across all contracts, is one of the biggest areas of dispute. And that's around not just kind of what happens on termination, but no, like termination notices in particular, and rights to terminate. So I think it's really important again, and it's that kind of shoving a contract in a top drawer, which may not be as relevant here, but go back and revisit what the contract says. You spent all the hours up front kind of getting to the going through the negotiations and getting to the deal you wanted. When it comes to these issues around termination, have a look at what it says. What are the rights? There's no two bites of the cherry. So in terms of sort of if you serve a termination notice for one reason and actually you were better off serving it for another reason, you can't just sort of withdraw that and walk back from it. It's very difficult to do that. So having to think about the rights that flow from different termination rights. Again, around material breach, having building into potentially the agreement different ways of defining what a material breach given right to termination might look like. If there's sort of remedial provisions within the contract, make sure you follow those notices and structures. So notice a breach, you've got 30 days or a month or whatever it might be to remedy, and making sure you just can't carry on with following that structure. And I think the other key thing in terms of litigation in particular, and again, I mentioned it earlier, is having the audit trail and having the kind of paper trail is invaluable. So just something to be aware of.
So now we're getting on to the area of possible disputes, liability, and so on. So this is the last of our four boxes. Beginning with liability and indemnities, what sort of trends are we seeing around things like liability caps? James, have you got thoughts on that?
We don't. I mean, if the agreement is between two corporates, there may not actually be liability caps if it is an out license, for example. That's commonly the position, say, between a biotech rights owner and a pharma company, for example. Quite often there won't be liability caps. You will however often and usually see a liability cap where a corporate is in licensing from a research institution, university, other charitable organisation, where I think it is important that that rights owner does limit its liability, because given charitable obligations, there is an obligation to look to mitigate risk. For the corporate, those caps could be reasonably low. So maybe I mean what we quite often see, if there are liability caps, there would be a general cap, and then there may be some particular carve outs, maybe around IP infringement, maybe around sort of confidentiality. There's probably no, you'd say, sort of novel trends in that case, Isabel. I think you would probably approach this generally on normal contractual principles.
Hmm. So around areas like governing law and jurisdiction, Becca, perhaps you could comment on what kind of things are happening in that area.
Yeah, again, there's definitely been a sort of uptake in terms of avoiding litigation and sort of court procedures. And so we have seen an increase in arbitration in particular and mediation, whether that's pre-arbitration or pre-sort of court hearing. I think the benefits of arbitration speak for themselves in terms of the confidentiality, sort of having experts determining what will likely be very technical and very expert and niche disputes. So there are some real benefits in kind of those areas and having that sector specific expertise. Again, it's just a case of really being mindful of what you were trying to get out of the agreement. And I think the impact of so much international and some of these kind of new technologies may have an impact on what governing law you might choose, what jurisdiction you might choose, whether you want to build in those kind of arbitration clauses instead of English courts or whatever it might be. So having to think up front and actually not that you want to always plan for it going wrong, but having an awareness of what those jurisdiction clauses actually mean if it does go wrong.
Ending up in a court somewhere else around the world, could be quite difficult, and so a lot of people do go for arbitration clauses where it's got a bit more predictability.
Exactly.
What other kind of sorry, James, go on.
I think I made the point earlier, but the governance structures can clearly help here, because actually if you've got those right, it almost fosters that collaboration, that information sharing between the parties, hopefully with a view to a more formal dispute arising further down the line. So those governance structures should be fit for purpose and should really try to foster that collaboration
we
between
often
parties.
see that sort of escalation, don't we, from the day-to-day governance through a dispute being referred higher up between the parties, and then if necessary, then you get into dispute resolution formally. There's a question just come up about which arbitration fora and rule systems we would normally recommend. I don't know if either of you would like to tackle that one.
Well, for most deals we see, it probably is going to be International Chamber of Commerce, and the great thing about that is you can have flexibility in terms of location. We've been relatively successful. We're acting for the rights owner to ensure it's an English law contract, which I think is important if you're based within the UK, but then you can be flexible around place of arbitration, and the ICC gives you that flexibility. I mean, the other one you quite often see is the Court of International Arbitration, but quite often if you've got an overseas licensee, they may struggle with that. It's got London as its name. They may think it's actually much more, although it's an international arbitration forum, it's much more sort of UK focused. Is that your view as well, Becca? That's certainly what we see.
Yeah, I was going to say quite often see ICC. I think I was just going to say the only thing to be aware of is what sort of automatic, for want of a better word, rules might apply when you do pick that arbitration forum, and whether it's again worth having a bit more detail within the agreement in terms of that arbitration clause, so making sure it's English governing law if that's the position you want to be in, and also what the kind of level of experience or sort of English law experience of preferred arbitrators and that kind of thing, or sort of building into the agreement as well that you want any arbitrator to have that life sciences industry and sector experience as well. So there are different ways of kind of, again, making the arbitration clause work for you as well. So it's just keeping those things in mind.
It can have quite an impact on cost, can't it? The tweaks that you make to how the process is to be run.
Yeah, that's right. And again, in terms of numbers of arbitrators and that kind of thing, location, again, it might seem a long way away, but if you've got an English law governing law, but the seat of arbitration is in Singapore, you might want to think about kind of travel and location and base for those kind of things. But
that's great, thank you. So these are the 4 topics that we've been discussing. I wondered if either of you wanted to make any final points that we haven't managed to cover so far. I mean, one area I think that might come up is where you have particular kinds of entity involved and what special treatment they require. So, for example, if a licensor is a charitable entity, are there special considerations for them?
Well, there are absolutely, and it's going to be driven by charitable legal obligations. So, by way of example, clearly ensuring that whatever is done fits with charitable objects. If it doesn't, does the deal need to be done through or executed through a trading subsidiary? But then ensuring that the charitable organisation gets fair value for its assets, which means it's difficult for it to grant rights to things happening in the future because it needs to be able to assess value. And there's just a general obligation to take reasonable steps to sort of mitigate liability, which sort of comes back to having liability caps. I think the key things from so if a charitable organisation is out licensing, it's been very careful about what is licensed. So quite often you would try to fix a description of that IP as at the date that the license is granted. Any future rights, it's subject to sort of options to negotiate, etc. And these are sort of fit with things like sort of your land models, etc. Thinking about on what basis the IP is licensed. So quite often, a university, for example, won't want to grant an exclusive license of know-how, and may be prepared to do it around registered IP such as patents, but not around know-how. Given the nature of the organisation, being a research organisation, and then having a real focus on reserved rights, ensuring that what is created can be used for commercial purposes, research, teaching,
academic,
etc.
Teaching,
absolutely, absolutely. So a range of considerations, absolutely. But clearly, the licensee, if it's a corporate licensee, they also need to be aware of this, because it's the regime that the licensor, the charitable licensor, is sitting within.
Mm.
I think universities and sort of spin-outs also need to be aware of kind of what IP rights, and students and some PhD students, if not deemed employed, can be subject to Consumer Protection Act as well. So there can be an interplay with sort of fair terms and regulatory terms around that as well to be mindful of.
And if they're not employees, it's getting anything that they create into the right pot and the right ownership.
Yeah.
There's a question here, Becca, around, you were commenting on termination earlier. So if people are not happy with how things are going, what kind of steps do they need to take?
I think sort of the most common thing that we see parties do is to just kind of do nothing, bury the head in the sand, and that's the wrong thing to do. Having that clean audit trail of sort of raising the breach and notifying the party of the breach is really important. Going back and visiting the contract and the contract terms in terms of that governance structure that we've talked about, and escalation, trying to kind of foster and keep that collaborative relationship throughout that is likely to be really important in terms of avoiding a kind of gritty dispute later down the line. So again, sort of having those open, careful but open discussions kind of at an early stage before parties get too entrenched, I think is going to be really important. And then if it does get to the stage of termination, be really, really clear on those kind of notice provisions within the agreement. I think parties, we've seen it sort of get caught out literally by serving a termination notice one day late. So just be really careful with those.
There's a question here about dealing with studentships and publication in a collaboration from a company rather than a university perspective. We are quite short of time, so if either of you got comments on that quickly, otherwise we can follow up later.
Well, I suppose the key issue will be around confidentiality of outputs. The company licensee is obviously going to be concerned that whatever goes out as a publication isn't going to give away confidential information relating, for example, to the product or to the corporate funder. There are ways around that in terms of lodging under confidentiality conditions in a university library if it relates to a thesis, but also the company licensee can ask for the standard protections in terms of delay to allow patent filing, the ability to remove confidential information relating to the company sponsor. But these clearly are going to be issues that are going to be raised and will be negotiated as part of a studentship. Conscious of time, but I hope that gives a really quick view. And obviously happy to follow up with the question if you feel that we haven't answered the question.
We'd be grateful for your feedback after the session. And just to let you know, we're planning sessions later in the year on competition law, regulatory trends, clinical trial contracting. But we'd very much welcome topic ideas if there's something you want us to cover. And once again, thank you very much to the speakers. Thank you to all of you for attending. It's been great, and we'll follow up with another session shortly. Thank you.